homelessness has been and is a recurring issue for just about every modern society. People that we call today homeless used to be called vagrants, and homelessness was called vagrancy. Now, vagrant, the word's Latin root is vagare. It's a verb, to wander. The OED, the Oxford English Dictionary, defines vagrancy as the condition of wandering, homeless, usually without regular employment and usually survived in poverty. That a synonym for a variant of vagrant is vagabond, and that comes back from the Middle English, and it was a person without home or employment. Different cultures have treated the homeless people differently. In many Asian societies, being homeless has a religious connotation. Wear a robe and carry a begging bowl, and they'll cut you a lot of slack. During the 19th century, the Ronin, R-O-N-I-N, the leaderless samurai used to wander about Japan. Picture the world that Kurosawa pictured in Yojimbo and Seven Samurai. Wandering monks and friars were something of a fixture in medieval Europe. Carmina Burana, which many of us know, the Karl Orff music, is set to modern music. The poems, the secular poetry and sometimes rival poetry that the Galliards, who were these not disenfranchised, but the disgruntled monks who wandered around, the balladeers performed. But as a rule, vagabonds were looked down upon. They were disparaged for being rootless, without fixed abode or employment. They were seen as being outside the pale of an ordered and orderly society. They were the other. Slide. No, you went too far. Back one. Maybe they're not in order. Let's keep going. Okay. Oh, you got the wrong slides up. You got the wrong book. That's last week's slides.
Yeah. Here you are. Yeah. Yeah.
Number 3. Right, there we go. And slide 2. There we go.
All right.
Okay, thank you. English law and tradition, which is at the root of our legal order, treated an able-bodied person who was living homeless as a vagrant. He was liable for punishment. The first English statute on this issue was promulgated in 1389. It was called the Ordinance of Laborers, and it was promulgated in response to the labor shortage brought about by the Black Death that swept Europe. It classified idleness and unemployment by able-bodied people, that's people other than the aged, the very young, and the infirm. It was a crime. It was punishable by branding, whipping, and forced labor. During the reign of Henry VIII, Parliament passed another Vagabond Act. It was called the Vagabond Act, and it outlawed idleness. Begging licenses were given to the aged and the infirm, but able-bodied people without employment were subjected to branding, whipping, and forced labor. Second offenses carried imprisonment, and third offenses you could actually get executed. That was in the statute. A statute under James I in the early 17th century provided that anyone wandering about and begging was declared a rogue and vagabond, and violators would often be branded with an R on their cheek and whipped. Lengthy imprisonment was provided for second offenses and exile for a third strike. Once Britain established colonies in the Caribbean and mainland North America, transportation and forced labor to compensate for the cost of compensation became a common punishment for many non-capital offenses, including vagrancy. So most of Britain's North American colonies adopted English law. In fact, they all did, including statutes that aimed to discourage vagrancy. Colonial Massachusetts, the Puritans, everyone in that society was expected to have a place, to be part of a social framework that reflected order and discipline, church, family, employer. The same went for other colonies. Unsupported women and children might be given a stipend by the local parish or confined in poorhouses or workhouses. But colonial societies had a problem of enforcement when it came to men, especially compared to Britain. In Britain, the difference was land. In Britain, all the land was taken up and was part of the ordered society and the social structure. But in colonial North America, the opposite was true. So incorrigible unemployed men might be whipped and pilloried, but they couldn't effectively confine them in poorhouses because they'd leave. It's too much land, too many places to go. So most towns were happy to simply see them go away, and they started ordering them to leave. Now, laws prescribing loitering, being a roustabout, begging, being a vagrant, stayed on the books most everywhere from colonial times until the mid-20th century. Enforcement varied depending on time, place, economic circumstances, and the like. And the idea that poverty and rootlessness, even in hard times, had a moral component went into this. And to give you an example of how it's illustrated in American society, I'm going to read you a section of a speech that Abraham Lincoln gave to a society of dairymen in Wisconsin in 1859. And his purpose was to explain the philosophy of this new Republican Party that had been formed. And he said, "The prudent, penniless beginner in the world labors for wages a while, saves a surplus for which to buy tools or land for himself, then labors on his own account another while, and at length hires a new beginner to help him. This is free labor, the just and generous, prosperous system, which opens the way for all, gives hopes to all, and energy and progress and improvement of condition to all." But here's the second sentence. "If any continue through life in the condition of a hired laborer or worse, it is not the fault of the system, but because of either a dependent nature which prefers it, or improvidence, folly, or singular misfortune." It's the dark side of what I call the dark side of the Protestant ethic. If people are responsible for their own salvation in the next life, they're certainly responsible for their own well-being and their own employment in this life. It's not the system. So don't blame the system. It's you. This idea, a dark side that limits both tolerance and compassion for those left behind or left out or whatever from the mainstream of society, became ingrained in aspects of Western culture. Stronger in some than others, more prevalent in some places than others, but always there. Homeless people are disparaged and romanticized, both, often at the same time, sometimes feared, often invisible. So what changed? Change is constant. You know, up until really during medieval times, the Renaissance, even the early modern period, life was considered organic. That God ordained the way the world was set up, and everything had a place in it. That was the way things were, and so you didn't object to where you were. You didn't try and change it. You accepted it, and your reward would come in the next life. And I tried to explain, when I tried to learn to explain this to students, I found a way to do it. And I remembered that there's a William Shakespeare in Troilus and Cressida, which was written in 1608, has Ulysses give a speech where he talks about the heavens themselves, the planets, in this center observe degree, priority, and place, course, proportion, season, form, office, and custom, all in line of order. And if you bust that up, take degree away, untune that string, etc., chaos follows, tragedy, discourse. And this is at the root of every Shakespearean tragedy. Hamlet doesn't kill the guy who killed his father and marries his mother. Othello and Desdemona disobey Desdemona's father and tells him not to elope, and they disobey them. Macbeth kills the king who's his guest in his home, and Lear divides his kingdom up before he dies. This is destroying the official order. Okay, that's what they call the Elizabethan world picture. And so a vagrant in that society, okay, that's what God intended. 165 years after Shakespeare, second sentence of the Declaration of Independence. We hold these truths to be self-evident that all men are created equal, endowed by the Creator with blah, blah, blah. What changed in that 165 years? Because history has changed. That's the one constant of history. It's changed. Things change. They are not going to be the same. The second Trump administration ain't going to be like the first. Whether it's going to be better or worse remains to be seen, but it's going to be different. Everything changes. So this is why. And of course, this kind of idea of change also impacted the way people looked on homelessness and homeless people and vagrants. Homelessness became epidemic in 1930s America. Let's see if we got oh, we keep going. That one's I deleted that one. There we go. Hooverville sprang up, usually on the outskirts of urban areas where they were mostly out of sight. Local communities were overwhelmed, underfunded, and unable to deal with the hordes of transients seeking employment. In 1936, Los Angeles set up what they called the Bums Blockade. Policemen, representatives in uniform of Los Angeles were stationed on the borders of Nevada and Arizona. Signs were put up basically telling people coming in, go to Central California where they need farm pickers, don't come to Los Angeles, we can't take care of you. The Southern Pacific Railroad in 1931 claimed that its guards threw some 680,000 people off freight trains. Anti-loitering laws were uniformly passed, often defining the crime as being without visible means of support, but such laws weren't always enforced, at least against white males, other than to make them leave town. Local sheriffs didn't have the resources to feed and house men who were willing to spend a few days in jail for 3 squares and a cot, because it was tough times. Homelessness then seemed to re-enter the public consciousness in the 1960s. And I remember this. Michael Harrington in 1962 came out with a book called The Other America, Poverty in the United States. And it became so prevalent that CBS did a primetime documentary in 1968 called Hunger in America. And it was, this became, it really entered the public consciousness at that time during the 60s. And in California, increasing numbers of mentally ill people became more visible. Changes in the law limited the number and duration of involuntary commitment to both narcotic addicts and people suffering from mental illness. In 1962, the Supreme Court held unconstitutional a California law that mandated imprisonment for narcotics addicts. And I'm going to talk more about that after the break. In 1967, California passed the Letterman-Petrus Short Act. I remember this because it involved me. I was working as a public defender. This law limited involuntary commitment to 90 days for involuntary commitments for mental illness to 90 days, and then only for those who were found that their mental illness rendered them unable to provide for their own basic needs of food, clothing, and shelter, or made them an imminent danger to themselves or others. And if you objected to this commitment, you were entitled to representation by counsel. And if you were indigent, you got a public defender. Now, this law was passed in 1962. It had an effective date of a year and a half or so later. I joined the Alameda County Public Defender's Office when I passed the bar in 1967. Before that, I'd worked for them under the work-study program, the Great Society, as a law clerk. So that's how I got that job. And I was assigned to the mental health court in Alameda County when this law went into effect. A judge picked, one of the judges who was assigned to it wanted to meet with the lawyers and the DAs and the public defenders who were going to be staffing his court, because this was all brand new. Then when I went to Los Angeles in 1969, I was assigned to mental health court in LA, it's County Hospital, or at Olive out in the Valley. And I remember, sitting in court every day representing people in these kind of commitments. And it was tough. I remember the movie One Flew Over the Cuckoo's Nest came out at this time, and I had to walk out of it. It was just too close. So it was really tough. And what happened is that that more and more of these people ended up on the street. And then in 1972, the Supreme Court struck down most of the anti-loitering and vagrancy ordinances for being too vague and violate due process. I'm going to go into this more after the break too. So most states and many localities replaced their vagrancy statutes with specific prohibitions of camping or sleeping in public parks, cooking, et cetera, except for designated places or with permits. But the total the total number of vagrancy arrests declined as a result of this. So more and more homeless people were out on the streets, and national statistics tell part of the story. Although census records are notoriously unreliable when counting homeless transient people, in 1984, the government estimated the national homeless population was between 300,000 and 500,000 people. In the 1990 census reported a transient population of 229,000, but even the Census Bureau admitted that was a gross undercount. The U.S. Department of Housing and Urban Development, as of January 2023, estimated that the homeless population was about 650,000, with California, Washington, New York, and Florida having the lion's share. Aside from legal changes, the increase in the homeless population during the 1980s in large measure was due to political developments, specifically the turn to the right that began with Reagan's election in 1980. I want to consider, statistics are always boring, but there's a couple that I found that I think are really relevant. HUD, the Department of Housing and Urban Development, their budget authorization for housing development in 1980, the last year of the Carter administration, was $74 billion. In 1987, which was the 7th year of Reagan's administration, it had fallen to $17 billion, a decline of $57 billion, 75% less. From 1980 to 1989, the entire safety net that millions of Americans relied on fell by a factor of 60%. That was Reagan. That was Reagan from 1980 to 1989. Yes, sir.
And later it was Clinton.
Yeah, and Clinton, welfare is ending as we know it, and requirement to work laws, the welfare law, put a lot more people on the street. Because if people are living at the borderline financially, and you take $400 or $500 a month away from them, that's the difference between having a roof over your head and not having a roof over your head. Now it's even worse. So this is what happened. At the same time, housing costs increased as the nation's supply failed to keep up with population growth. Inflation went up too. Both private charities and local governments tried to ameliorate the problem. In the 1990s, saw a growth in the number of privately and publicly funded soup kitchens and shelters, especially privately funded, especially in the urban areas with the largest concentration of homeless people. And the problem has only gotten worse. During the economic collapse that began in 2008, thousands more people lost their homes and jobs. And a decade later, still many had not recovered. Federal and local budgets varied, but never kept up with need. And then the pandemic hit, with even more economic and social disruption. And possibly more vexing is that while homelessness increases, it seems that communication and commonality between city authorities and the people and people who are okay and the homeless declines. Where the authorities see encampments and unoccupied properties as dangerous, as risks to public health, as blights on neighborhoods that decline property values, homeless people see encampments as refuges, as communities and places of safety. And media coverage adds to this disconnect because media naturally responds to those who buy the newspapers and patronize advertisers. So with the worst homelessness stigmatized as the other and often blamed for their own plight. And that's the cultural reality. And Santa Cruz isn't unique. Oh, I get to go one more. I think I got the, yeah. There are local circumstances that makes it really difficult to deal with the problem. And I got this because I was on the grand jury for a year and we looked into this. Our county's population of about 260,000 as of 2023. It's not one of California's biggest, I think we're 25th. The most recent point in time count taken by Santa Cruz County earlier this year found about 2,000 people living as homeless. In prior years, the county estimated that its point in time surveys reached about 90% of the homeless population. So 2,000, 2,020, 2,000, 2,500 is about that. But we're a small county. And most of the county's homeless population is right here in and around the city of Santa Cruz. The city's population and tax base is based on a population of about 70,000. That's not very big. We are a small town. Why are all the homeless around Santa Cruz? Well, because this is where the county jail is. This is the county seat. This is where Emmeline is. This is where services are. And so they're here. And anybody who, I ride my bike path constantly, and the bike path up along the river, and you see the problem anywhere you go in the city. If you drive up to Costco, you see homeless people. You go to De La Viega, there's a whole large encampment in De La Viega. So although the city has about a fourth of the county's population, the vast majority of our homeless population is here. While the city's police and fire departments bear the brunt and the cost of law enforcement and fire prevention and homeless encampments, all the money for providing homeless services comes from the state and is administered and controlled by the county. That's the Board of Supervisors. So there's this disconnect because the city and the county don't talk to each other very much. And for many years, our city council recently was dysfunctional. And Santa Cruz just has recently changed. Where it's interesting, our speaker, I think, at the next meeting is the former mayor. When he was mayor, we had a weak mayor system that the mayor was just a member of the city council. It was being a mayor was more ceremonial than it was substantive. But we've recently changed to a strong mayor system, more like Los Angeles, where the mayor has administrative authority and administrative power. So it's going to change. Santa Cruz is going to change. How, I don't know, but it's going to change. So this is the problem. Smaller communities like Santa Cruz have limited financial resources compared to the magnitude of the problem. For the past decade, the civil grand jury as civil grand juries in counties throughout California, have issued reports that deal with homelessness and related issues. It's a complex issue that impacts about every community in the state. Problems range from managing and policing encampments, fire prevention, sanitation services, city parks, people sleeping on other people's lawns, watershed and flood zones management. All of this stuff comes into it. Sometimes different entities control the land apart from the government, and apart from the entity that's responsible for patrolling, supervising, and maintaining or dealing with the problem. We had that problem here at the intersection. Remember the encampment at the intersection of Highway 1 and Highway 9? Who do you think? Caltrans owned the land. You couldn't do anything without the state acting, and the state's got its own problems and its own time schedule for doing things. And it actually, that didn't get cleared up until they were at risk of losing the federal money that was going to pay for the redoing of that intersection. And that's finally how we got the ability to clear that out. So in any event, that's a short history and a glance at the issue from a local perspective. And I know I've gone pretty quick. We've only gone a half an hour in. but this is a natural spot to break because then I'm going to start going into the law. So how about some questions? Yes, sir.
You know, some years ago, I heard that the cost of one homeless person in Santa Cruz is about $70,000. Have you heard that number?
Yes, I have. The comment was it's the cost, and this for the people on Zoom who can't hear you always. The gentleman Gunther reported that the estimates were that the cost of a homeless person in Santa Cruz, when you factor all the things that go into it, police, fire, everything else, housing, whatever, it comes to about $70,000 each. And yes, I have heard that number, and the city of Santa Cruz doesn't have the tax base to support that. Yes, sir.
But then I also, what you said earlier, that sometimes the difference of $500, $1,000 makes it whether that person can pay the rent or not.
Yes.
And I always thought, doesn't make much more sense, give them $500 or $1,000.
That's a very good point. The add-up question was, well, would it make sense then to basically just give them some money rather than spend $70,000 supervising them as a homeless person, give them enough money that maybe they can get some kind of housing. Well, there's two issues with that. One is, where in Santa Cruz are you going to find housing that's going to do? Because we know that a one-bedroom studio here goes for $1,500 if you can find one. Not anymore. It's even more.
Like, one bedroom studio in those new apartments is $3,050.
Unless you got Section 8. Let me continue. The city of Stockton actually tried that. The mayor of city of Stockton came up and that they were just going to give everybody $500 a year or $500 to help them to get them off the street. The city ran out of money, and Stockton has got such high unemployment and such low budget that even though they have more people than we do, their budgets are even tighter and their social services are even tighter. And so it has a much larger minority and homeless population per capita. Yes.
Is something like that something that happened for the people at the St. George when they were going to quadruple their rents there?
The question was, did that happen in St. George? You mean, St. George?
There was an effort by whoever owned, I don't know who owns the building, they were going to quadruple the rent that these people were paying, making it impossible for them to stay and therefore become homeless. I thought there was some money from.
Yeah, there might have been. I don't know enough about that to comment on it. I do know that the most recent grand jury issued a report on housing. They called it Housing for Whom. And the issue was, Santa Cruz put a lot of money into creating additional housing. If you drive, around, you just see the buildings going up. And the issue was, who's living in that housing? What percentage of it is going to be the lower people? What percentage is going to students, et cetera? And what the grand jury found out was that no one's keeping track of that shit. And so their report was to suggest that maybe the city council could have the city, since they're spending all this money on housing, find out where it's going, who's living there. And the response from the city was, well, this is all privately owned, and it's not our responsibility to keep these records, and we don't have the time or the inclination to do it. Well, I think they're going to have to start doing it because it's brought up some issues. Yes, you had your hand up.
I was just thinking worldwide, from a peaceful point of view, when people lose their land for whatever reason in India or South America or whatever, they end up in slums like this on the borders of big cities, Rio or whatever. It seems to be the same.
It's not, yeah, we are.
Your land, you end up in the slum in the city with a cardboard house.
Judy's comment was very apropos, is that in your other foreign countries, you have a very similar problem where Hoover, the functional equivalent of Hoovervilles, or I think, what's the word for in Rio, the hillside? Favelas are up, and we have those, you know, that's the functional equivalent of a homeless encampment. And so this is, as I said, this is a universal problem. We are not alone. Yes, ma'am. Some European societies work it a little differently. And I think there is probably more inclination for public housing because their societies are less individualistic. And, you know, they also have universal health care in most European countries. So there's a cultural difference here. What would it take for that to happen here? I think a cultural shift, major cultural shift. Yes, back there.
Yeah, I should point out that in the most recent homeless count in the county, which
Yeah.
was earlier this year, Santa Cruz City had a big drop in the number of reported homeless. So you're saying anything to do is pointless. However, the county still had an increase, particularly down in Watsonville, and particularly a lot more Latinos now.
Yeah.
reporting,
Yeah, and Live Oak, which is part of the county, you know, they don't have to go very far to get out of the city of Santa Cruz. You know, they just go up Highway 1 past Schaefer and they're outside the city.
I guess my point is, you know, don't denigrate the efforts we're doing locally, but
No, it's a countywide, it's not exclusively a local problem. There are situations that make it a little tougher for the city of Santa Cruz to deal with this problem, but some of the people leaving the city is making that a little easier for them. And I'll grant that, yes, it's true, because this change happens, yes.
At one time, a great deal of public housing was being built,
Yeah,
and you're saying it's a cultural thing. What cultural change occurred between the time that
there was just so many homeless. The question is, what cultural change? Why are we starting, if our culture is still this individualistic, how are we coming to build this housing?
No. Why are we no longer building public housing, which we did in like the 1940s?
The big public housing projects that used to be built, because they were seen as a way of dealing with the Hoovervilles and then, but I think they stopped for a number of reasons. One, they became slums themselves.
Because they weren't maintained.
They weren't maintained. The people who lived in them didn't take pride in them to some extent. They weren't maintained. The ownership was not maintained. And they were high density, high drug use. There was just, and why do we not build them anymore? Because I think that part of it is that personally, I think there's a disinclination to spend the money to do it. I once said, we have a choice in our elections. Do we want to be Mississippi or Sweden? And most Americans prefer Mississippi. I mean, to be, you know, I shrug my shoulders. I'm no expert on this. I'm a historian and a lawyer. And what do I know? Constantine.
I think just going back, when we call low income, that number is really, I think, the key to what we call to the kind of housing we build. In other words, some of the things they call low income are really out of the question for homeless.
Yeah, Constantine made a very strong, good point that the standard of poverty in terms of low income is itself a moving target, and it's not necessarily very realistic today in terms of what it costs to live. You know, and different communities are trying different things. Somehow, some communities are basically using mobile homes or prefabricated housing just to build cubicles to get people in.
Tiny houses.
Yeah, but there's also an aspect of the homeless, of the transient population that isn't going to move in there. That isn't going to be there. One of the things that I remember, there's a fellow named Steve Lopez who wrote for the LA Times, and he wrote a series of articles. They made a movie out of it. He met a homeless fellow who had severe schizophrenia, who was a Juilliard trained concert violinist. And when he was first put into, when Steve Lopez first found him an apartment to go into, he couldn't stay there. He had to go back to the street. That was his comfort zone. Apparently, he's now, with medication and other things, he's now apparently in housing. But there's also, this is another thing that adds to the problem.
The absence of safety net, I mean, the.
Yeah,
mental-
Yeah,
You know, it's not.
the United States, I'm not gonna go there.
When you make these comments about certain people, these are the minuscule, very minimal minority, I would say, of those people who are homeless. Yes, there are drugs. Yes, there are people who don't want to live in an apartment. Yes, but they're minor, and this is what confuses people. I think it's minor, and they have been proven statistically.
I'm not, that's something I don't know. I'm not, I haven't seen enough statistics and seen enough evidence. The stuff that I saw was that that it's a much higher number. And the reason is because so many people who suffer from mental illness are not counted as suffering from mental illness because they're not being treated, or they're either not accepting treatment or they're not being treated. I do know that most sheriffs that you talk to, who jail administrators, say that their facility is now the largest mental health treating facility in their counties. And the jails are, since the pandemic, the jail populations have markedly declined. So where are these people going? Many of them are on the street. The people who would be counted as having a mental illness and incarcerated are now on the street, and they're not being counted as mentally ill because they're not being treated.
One of the things like that when you're talking about people that don't want to go to a room, they don't want to stay in a room, even if they have the opportunity, because they have community on the street.
Yeah, a very good point. Some people don't want to go into housing because they're losing their sense of community that they have with their people on the street in the aggregations of homeless people are on the street. I mean, you to read stories of the hobo camps during the 30s and 40s and 50s. So we could talk about this for hours and still always define more problems and things that add to the problem, but I don't hear any solutions.
Ironically, one of the things that they say about people who are isolating themselves and living alone is to create community. And here we have people who want to stay in community.
And yet the authorities in many places are disinclined to have those communities because of a number of issues, including health, sanitation, fire prevention, property values. One of my closing lines, I go later and I'll throw it out now and you'll hear it twice. NIMBY is alive and well. Mark, yes, in the back.
I hike frequently in Pocono, and on side trails in Pocono, there are really communities that are set up with little street signs and I met a man coming in, and I think about it, they have to bring everything in, water and everything. You're not allowed to have a bike in Pocono, so they use a bike sometimes, but it's very risky. And this fellow had a solar panel to charge his cell phone.
Right, and he probably has a butane tank to cook his food.
And it creates fire.
And you've got all this plastic tinting around, which is extremely flammable.
It was really impressive.
This picture was taken at the corner at the intersection of Highway 1 and Highway 9.
Yeah. Absolutely.
Yes.
4 years ago, we lost 911 buildings in this county fire.
We lost 900 buildings. Yes, that was the CZU fire. Most of them were up in the mountains.
That's right. And less than 150 have been rebuilt.
That's right. That's another issue. There's 3 grand jury reports on that I'm aware
So
of.
I'm one of them. No, this is not funny. No, many of them are not. Listen, before the fire, I had a residence. I was a homeowner, all right? I was reverse mortgaged, so I didn't have to worry about making mortgage payments. I had a cabin that I rented out, that was my pension. I lost both. I had insurance, okay, because I was middle class, I did all the right things. I had insurance, and I got insurance on both those houses. And between the two, I had enough, just enough, to get a contract to rebuild my residence, which I could have done, except that the county's requirements added $300,000, almost doubled the cost of the rebuild. I'm living on savings right now. I'm 80 years old. I'm 80. All right, and I've been middle class and housed my entire life. And now I'm paying $1,200 a month to rent a room. And when my savings are gone, I'm on the street. So it can happen to anybody, and it can happen to you.
Okay, one more and then I think we're gonna take a break.
A couple of years ago, there was in the Sentinel an article about where are the homeless people in Santa Cruz coming from? And to my surprise, the majority were local people who lost their job or were mentally ill. And I want to say in Germany, at least in the 60s, the city of Hamburg, they had several houses for mentally ill people, but only for those who were born in Hamburg. Not for people who are coming from Munich or from other cities. And I would be gladly contributing with my taxes to support those kind of houses.
Run for the city council. Okay, let's take a break. 5 minutes, everyone. You're 10 minutes.
So.
Hundreds of years, thousands of years.
Okay, thank you all. So far, this has been a great discussion and I love it. Okay, so let's go on. So where does homelessness meet the law? When society seeks to exert control over its members, it does so in a number of ways, often in combination. Certain activities that threaten public health and safety can be declared a public nuisance. The authorities and/or those who cause the nuisance can be ordered to take steps to remove it. Or society may declare that certain conduct is outside the pale of acceptability and declare that such conduct is a crime, and if someone committing it is liable for punishment. This brings into play the concepts of due process and the Eighth Amendment, which prohibits cruel, excessive bail fines and cruel and unusual punishment. Can you put that one up, the slide before this, which is in the wrong order?
Oops. Oh, it was the one before.
Not that one. Not that one. Oh, it's not that. The one that.
All the way back.
This one right here.
Okay.
Here you go. This is cruel. This is the Eighth Amendment. Whatever that means. And that's where it comes from. As I mentioned, vagrancy laws in one form or another were ubiquitous in British and American law. Early colonial society established laws for their communities, pronouncements of colonial legislatures of the rights and wrongs, including prohibitions of idleness, subjecting those found guilty to whippings or other imprisonment. Both before and after independence, just about every city, state, and township had some type of anti-vagrancy law on their books. The 14th Amendment made the idea of due process binding on state and local governments, and ultimately the Supreme Court held that due process required that all the Bill of Rights are binding on all levels of government. Now, a key component of due process is that crimes must be defined in statutes with sufficient exactness that people knew or could tell if they bothered to read it what conduct was prohibited. Most anti-loitering laws were designated very minor offenses with light punishment, a little bit of county time, some small fines, etc. And rarely were they addressed in appellate court opinions, in part because people charged with them had neither the resources nor inclination to do much about it. But that changed, especially in the post-World War II civil rights era, especially when local communities applied such laws against non-white minorities or against interracial groupings, where they basically tried to use those laws to prevent social activities which they disagreed with. Before the break, I noticed that the Supreme Court held that most vagrant laws were too vague to satisfy due process. The case is 1962, came up in 1962. The name of it is Papachristou, Papachristou, that's not on the exam, versus City of Jacksonville. The facts are important. The Supreme Court consolidated 8 separate appeals from convictions under a Jacksonville ordinance that lumped together a whole litany of forbidden acts, including night walking, being a lewd and dissolute person, prowling, wandering without any lawful purpose or object, or being a habitual loafer. There was a whole list about 5 lines long of all these types of things that were within this one vagrancy statute. Punishment for violations included fines and or up to 30 days in jail. Now, the lead case involved the arrest of 4 young people in a car who were accused of prowling by auto. What I used to call cruising. I mean, I was guilty of prowling by auto up and down Hollywood. For most of the time from I was 16 to 18. Now, this car had 4 people in it. 2 were young white college co-eds and 2 were young black guys. And after they were arrested, the police department called the girls' houses and said to the people who answered the phone, "Did you know your daughter was hanging around with a couple of Negroes?" The Supreme Court unanimously held the ordinance was unconstitutionally vague. Due process demands that a criminal statute must give a person fair notice of the specific criminal act which the statute prohibits. Further, loosey-goosey statute language, in quote, encourages arbitrary and erratic arrests and convictions, close quote. Hence, loitering is unconstitutionally vague, but sleeping in a public place and camping or housekeeping in a public park were just fine. Or were they? By the way, in addition to erratic, arbitrary, erect, it's also an affront to police authority. In other words, that was another thing that the Supreme Court said was at issue in these vague statutes, that the police were basically using it to rouse people they didn't like. And of course, when they changed this law, the number of vagrancy arrests went down all over the place because the police knew that their cases couldn't stick, that the city's attorney, the DAs couldn't prosecute them. And basically, it's a black mark on a cop who will take people for arrest who don't get convicted. Now, consider I want to shift focus to the 8th Amendment. Its history goes back to the 16th and 17th century. For most of the Middle Ages and the Renaissance, torture to exact confessions was the norm, especially if the subject was not a member of the aristocracy. In 1685, shortly after Charles II died and his kid brother James II became King of England, a revolt was suppressed. There was a revolt led by Charles II, one of his illegitimate kids, and the revolt was suppressed. And a court sentenced just about everybody who was suspected of favoring it, guilt was assumed, was assigned to a very painful and gory death, including what they call hanging, drawing, and quartering. Basically, you hang someone, but you cut him down before he's dead, you cut him open, you pull out his guts, and then you have a horse divide him into 4 parts. These court proceedings came to be called the Bloody Assizes. Now, assize, A-S-S-I-Z-E, is merely the Old English name for that period of time where the trial courts in England were devoted their time to criminal cases. What they did is every couple of months, the court would set aside all the civil cases and devote itself to just handling the backlog of criminal cases. And then they'd get back to doing the civil stuff. Today, we don't do that. We separate our civil and our criminal calendars, and both are going on simultaneously at all times. But they used to divide them. And that was the case here too. that courts didn't always sit in session every day, all business days. They had court sessions, and a session in Britain was called an assize. 4 years after this, in 1689, as part of England's Glorious Revolution, Parliament passed what they called the Bill of Rights to define an English basics rights. There are about 20 provisions. The 9th one of them stated that, quote, excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. That's the language that became our 8th Amendment. Now, culture is critical. Don't think that just because this was passed by Parliament in 1685 that it ended all cruel punishments. Cruel punishment were ubiquitous in Great Britain and even in colonial America well into the late 18th century. Whippings, branding, especially for slaves, public humiliation, all were constant. And I want to plug a book. It's called Inventing Human Rights. The author is a woman named Lynn Hunt, who happened to be my mentor at UCLA when I first went back to school when I was in my late 50s. Decided that I wanted to become a historian. Lynn is now retired. She was had a chair in European history there. She's written several books on the French Revolution, and she was selected to edit a student-oriented publication on the Declaration of the Rights of Man and Citizen that came out of the French Revolution, which the work she did on putting that book together caused her to look back in this. And it's an intellectual and cultural history of the idea of human rights. And for those of you who are interested in it, it's really one of the best places to get in a very readable book that is less than 300 pages, even including the notes. It's before the notes in the appendix, it's only 200 pages. So it's definitely readable. Yes, sir.
What's her name again, please?
Lynn Hunt, Lynnhunt. And the book is called Inventing Human Rights. If you want to take a look at it after, you can come up and just take a quick gander at it. I want to make a plug. First time I've ever plugged a book in this series of classes. But Lynn is a good friend. She's also a very good golfer. Susie's played golf with her, that's to it. And she's a wonderful writer. One little story. She taught a class. One of the first classes I ever took when I decided to go back was a class on the philosophy of history. And there's a German philosopher named Hegel. Some of you may have come into contact with him, who is really hard to read. In 2 lectures, she laid out Hegel that made it both understandable and interesting. So she's really good. Yes, Bob. Ron.
Therapist?
Yeah, are you a patient or a therapist?
So you said it's the only book you've ever liked, which means you don't like the one you mentioned earlier, Gerrymandering, the other American?
I know when I suggest reading, this is a more current book. That's a fascinating book, but it's writing about a time that was 80 years ago. It's a historical book. No, I'm writing this on a current subject. If Harrington were to revisit that subject and write about it today, that might be a book that I'd be interested in reading, and I'd certainly be interested in plugging it. But I wanted to plug Lynn's book for a number of reasons. Okay. When the first Congress was considering the proposed amendments, you remember some of you took a class I gave last year on the origins of our Constitution. When the Constitution was being debated, the Massachusetts, New York, and Virginia, it was certainly not a sure thing that they'd ratify it. And the principal objection to it was there was no Bill of Rights, no Declaration of Rights that limited the federal government to protect people's rights. And Madison, who originally thought we don't need to have a Bill of Rights because the federal government's a government of delegated powers. And if we list some rights, people might assume that rights not listed could be invaded. So he didn't think it was a great idea. But then when he realized that to get it ratified, that if he promised I'll add a Bill of Rights later, that would get the votes, he did. And he basically said, if you ratify the Constitution, the first thing that the government's going to do is we'll put together a series of amendments to add rights, bill of protections. And so, and Madison kept his word. And when the first Congress was considering the proposed amendments, one was this Eighth Amendment. And when the draft lifted the language directly from the English Bill of Rights. Well, actually, he lifted it directly from the Virginia Constitution that had been adopted by Virginia in 1776, which in turn had copied it from here. And in fact, 7 other states had done the same thing, had adopted a Bill of Rights before 1789. And so they all had this, 10 of them had this in their constitution. But it's interesting, when this was being considered, there was almost no comments or that are recorded about what the members of Congress debated and said about this, except one comment. There was one representative who noted that the language, quote, cruel and unusual, close quote, was so vague that its meaning would come from the mores of society, which was always changing, which he acknowledged. Okay, and as drafted and up through the 1950s, any cases involving the application of the Eighth Amendment focused on 2 things. One, was a fine or bail excessive? Or 2, was the punishment cruel and unusual? And the cases basically dealt with the possibility of being deprived of citizenship, the length of time of a sentence proportional to the crime, etc. But a case that came down in 1962, Robinson versus California, changed that. And I mentioned this case earlier because it's the case that held that a California statute that said using or being addicted to narcotics was violated cruel and unusual punishment. The law provided that anyone who was convicted under the law, which means you could be convicted for being a narcotics addict, if they didn't have any actual evidence of use, penalty was up to a year in jail with a 90-day minimum. And it was planned to get addicts off the street. That was the plan of it. A defendant had been stopped on the street by a patrolman who noticed needle tracks and scabs on his inner arms, and he was charged with being addicted to illegal drugs. Now, I was in the public defender's office shortly after this case came down. And it was kind of a famous case because a LA public defender represented this guy and actually had taken it up to the Supreme Court. He didn't write the brief or argue the case. They got a more experienced lawyer to do that. But a guy in the LA public defender's office thought enough about this case that he made it his job that he was going to take this up there. In any event, a divided Supreme Court reversed the conviction. It held that while the state can prescribe, make illegal using, possessing, or selling a narcotic, the Eighth Amendment prevents violating, you can't make it a crime to be addicted to narcotics, because that makes it a crime to have a condition. Just as a state, quote, just as a state cannot make it a crime to be mentally ill or a leper or be afflicted with venereal disease. The opinion also stated that while 90 days in jail up to a year is not itself cruel and unusual punishment, quote, even 1 day would be cruel and unusual punishment for the crime of having a common cold. In other words, this was the first time that the Eighth Amendment was ever used to define and limit what a state could make illegal, what a state could prescribe for conduct that a state could punish for. That was covered, this is the first time the Supreme Court said it was covered by the Eighth Amendment. What happened after the war isn't what you think, because justices had some concern about applying the Eighth Amendment beyond its traditional focus. In 1968, in a case called Powell versus Texas, the Warren Court held 6-3 that an alcoholic who was convicted for being drunk in public was the Eighth Amendment did not prevent that, because the statute banned the act rather than the status or condition. Even if he could not prevent himself from committing the act, he still committed the act, and that's what was prescribed, not the condition of being an alcoholic. A number of other states criminalized the act of using narcotics and specifically said that being addicted was sufficient evidence to establish illegal use. So they're going at it backward. The crime was using narcotics, but the evidence that you committed the crime was your addiction. And over the years, the Supreme Court refused to take those cases. They refused to allow challenges to convictions for narcotics, where the only evidence of use was the defendant was addicted to narcotics. And all this leads me to the case of Martin versus City of Boise. It was decided by the Ninth Circuit Court of Appeals in 2018, modified a few months later in February 2019. Homeless people in Boise had been cited for infractions under a Boise ordinance that barred sleeping and camping on public property. The city's policy was not to enforce the ordinance if shelter beds were unavailable. I mean, not to enforce it if shelter beds were unavailable. But the police were never told that shelter beds were unavailable. And the reason is that all the shelters, even if they had extra beds in them, closed their doors at 6 p.m. or 8 p.m. And so somebody at 11 o'clock at night, there's no, the shelter has beds, but they're unavailable. Police were never told that. And so they arrested people. The plaintiffs won in the district court. They cited the Robinson case, and the city appealed. And when you appeal from a district court, the first place your appeal goes is to the federal circuit courts. Now, there are 13, right now there are 13 federal circuits. Each circuit has a specific area by states that it covers. And all the district courts in that circuit are bound by the decisions of their own circuit court. But they're not bound by the decisions in another circuit court. They can refuse to follow them. And there's so many cases. The Supreme Court only takes the cases it wants to take. But the circuit courts have to take every appeal that comes out of the district courts. They don't have a choice. And there's too many of them to have all the judges hear every case. So what the circuit courts do around the country is they assign 3 judges to every case. When a case comes down for an appeal and they open a file, they take 3 names out of a hat, which are all the judges who are circuit judges in that circuit, and those 3 names become the panel that hears that case. If you lose the case, you got 2 choices. You can ask those 3 judges to rehear it. You know what their answer is likely to be. Or you can ask the full panel of all the circuit judges to hear the case. And then if a majority of the judges in the circuit say yes, then they rehear the case sitting as a whole group. And there's about 18 or 9, there's usually 17, 21 or so judges in every circuit. And it's usually an odd number, because you always want to have an odd number of judges so that you can get a decision. And that's why you have a 3-judge panel in this case. And I just wanted to explain a little of the procedure.
Doesn't that really slow down the legal process?
No, it actually speeds it up. Because if every case had to be heard by all the judges in the circuit, they'd never have time to hear all the cases. So they've got, usually there's 8 or 9 panels of 3 judges each. So there's 27 judges in the circuit. You could have 9 panels hearing 9 cases at the same time. And the judges hear a number of cases. They don't hear them one at a time. They may have 3 days of oral arguments, and they get together like Supreme Court, they talk informally, decide what the rule is going to be, and assign one of the majority judges to write an opinion. There may or may not be a dissent. So it works. The system works in that sense.
Related to that, there must be frivolous appeals.
There are frivolous appeals, and some of them are handled. Barry's question was there might be some frivolous appeals. There are, and they get rid of them very quickly.
Okay, they can really just.
They basically said the issue in this case is so-and-so, there's no issue here, and judgment affirmed. Now, you can take that, that's a final judgment, you can take it up. What are the chances the Supreme Court's going to hear that? Okay. A 3-judge panel defined the case. They defined the issue in their holding as follows, and I'm going to quote. We consider whether the 8th Amendment's prohibition of cruel and unusual punishment bars the city of Boise from prosecuting people criminally for sleeping outside on public property when those people have no home or other place to go to. We conclude that it does. Close quote. That is the decision, this Ninth Circuit decision in Martin versus City of Boise. Now, the opinion noted that the Eighth Amendment has three effects. One, it limits the type of punishment. Two, it bars punishment that is grossly disproportionate to the severity of the crime. No problem there. Those were traditional. That's what it was designed for. Three, it limits what the government may criminalize. It says that as a third use of the Eighth Amendment. This was new. This is what the Robinson court had said, but no other court had followed it. So its only authority was the Robinson, and it cited Robinson, and it cited dicta in one other case it cited, that the Eighth Amendment imposes limits on what can be made criminal and punishment as such. Now, this case that is cited was a case from 1967 called Ingraham versus Wright. That will not be on the exam. But the case involved a really unusual set of facts. A bunch of junior high school kids complained about being paddled by school officials, and they said that that violated the Eighth Amendment. And they used a fairly, it was like the paddle was basically about the size of a pickleball paddle, but it weighed 4 times as much. It was more like a racquetball paddle. It was solid wood. And if 10 whacks on that and you're behind, it hurts. And the evidence was that this school handed this punishment out fairly liberally. It was in the South, of course. Now, the Supreme Court held that the Eighth Amendment, in that case, the Supreme Court held that the Eighth Amendment applied only to criminal cases, and being paddled by a school vice principal was not punishment for a crime. It was not a criminal case. Now, remember I've mentioned in prior lectures that sometimes a court gets in trouble when it says too much. That what you should limit, that judges should limit their decisions to that which is necessary to decide the case in front of them. Well, if the decision is that being paddled by your school principal is not a crime, why is the court defining what crimes, the effect that the Eighth Amendment has on criminal cases? Once you say this isn't a crime, the Eighth Amendment only applies to crimes, you lose. There's no reason to define what is or is not included in the Eighth Amendment's application to criminal cases. That's what's called dicta, obiter dicta, Latin meaning that which is not necessary, D-I-C-T-A. And when you cite dicta, you're always going to get in trouble because you may not get it filed. The Ninth Circuit opinion deciding Martin versus Boise relied heavily on the Robinson case and this other case. It said that being homeless is a status, no matter the reason. Quote, whether sitting, lying, or sleeping are defined as acts or conditions, they are universal and unavoidable consequences of being human. Accordingly, violating the anti-sleeping ordinance is involuntary and inseparable from status. Just as the state may not criminalize being homeless in public places, the state may not criminalize conduct that is as unavoidable consequence of being homeless, namely sitting, lying, or sleeping in the streets. Close quote. Now, Federal Circuit Court of Appeal decisions are binding precedents on the district courts within that circuit. And for the Ninth Circuit, that includes the West, Alaska, Hawaii, California, Oregon, Washington, Nevada, Arizona, Idaho, and Montana. But decisions in one circuit are not binding on district courts in another. And circuit courts sometimes disagree with themselves. And of course, one of the principal purposes of things the Supreme Court tries to do is resolve conflicts within the circuit. Now, Boise's attorneys asked the Supreme Court to review the Martin case, but the Supreme Court declined to do so. And that decision in 2019, declining to take the case, left the Martin case, the law, the final word, in the western states. And that had a real problem here in California and in Santa Cruz. Now, the Supreme Court never says why they declined to take a case. Why do I think they declined to take this case? 3 reasons, 3 possibilities. One, there wasn't yet a conflict among the circuits. This is the first time a court had done this. Secondly, and I think more importantly, I think they wanted to see how the western states dealt with the issue. Did it become a major problem? Were there a lot of complaints about it? Or did people just go along with it and what have you? And how the public reacted. It also might have been, and I don't have the dates right in hand to put this down, but I don't remember if there might have been a vacancy on the court at that time and only 8 justices. And on heavy cases, or cases that assume a lot, the Supreme Court generally doesn't like to take a case that's not going to be decided by an odd number of judges. Because a decision that splits 50-50 is no decision. And it leaves the circuit court, it's like they don't take the case. So if the Supreme Court rarely takes controversial cases when there's only 8 justices. Now, they might take a case when there's 9 justices and get stuck with 8 by the time they hear the case. And sometimes in that case, what they'll do is they'll just postpone it until they get another judge appointed. Or if it's clear that they get a 5-3 ruling, that it's clear they got the majority, they'll go ahead and decide. But so that's why the Martin case was not immediately accepted by the Supreme Court. It had a profound effect on cities and states within the Ninth Circuit, especially during and after the COVID epidemic, where California had the largest number of homeless people in the country. The reasons included, we had some of the most expensive rental rates in the nation, along with housing shortage, expanded pretrial release programs during the epidemic, where people who would have been in jail because they were unable to raise bail were released. Because jails are super spreader locations, one of the ways public health got with the sheriff to try and solve to prevent COVID from being a problem was to reduce the jail population. Because when COVID hit, the jail our county jail had a maximum capacity of 312 people. In April of 2019, there were over 375 people in the jail. And there's a lot of reasons for that I'm not going to go into, why our jails were so crowded before the COVID epidemic. But when COVID hit, massive OR releases became the norm to try and keep the jail population down. Because everybody coming into the jail had to be quarantined for 72 hours to make sure they weren't carrying COVID. And then people were being tested. It cost a lot of money and it was difficult. And jails are super spreader locations. And by the way, during COVID, they only had one instance of one inmate being, no inmates came down, but only 2 of the jail deputies, and they caught it at a party, an off-duty party, a beer bus that they had gone to. So that they actually, sheriff kept COVID out of the Santa Cruz County Jail during the COVID epidemic. But one of the ways they did it was they substantially reduced the jail population. So that happened. So here in Santa Cruz, to clear a homeless encampment in San Lorenzo Park ran smack into the Martin case. You might recall there was this huge encampments that took up a lot of San Lorenzo Park. The park really couldn't be used by the set of people who just wanted to go there and have lunch. And a lot of the park is the floodplain of the San Lorenzo River. And it wasn't until they got a mandate from the Army Corps of Engineers to clear the floodplain, and they opened up parts of De La Viega Park for a homeless encampment that they were able to close that encampment. And I mentioned the encampment over at the intersection of Highway 1 and Highway 9. Finally, they were at risk of losing the money from the federal government to do the improvement, and that plus other places got them to clear that. Yes.
When the sheriff, who gets the credit for clearing out the jails? Is that a problem between sheriffs and court?
Yeah, it's not a problem. What happens is and there's been a movement in California to reduce the number of people confined pending trial. There's a disconnect between the presumption of innocence in keeping someone locked up until he goes to trial, especially if it's not a super dangerous case. If some guy is accused of petty theft, which you normally carries a $5,000 bail, not a lot of bail, which for $500 to a bail bond gets you out. But a lot of people don't have the $500 or the bail, they don't have family where the bail bondsman is willing to post a $5,000 bond to get them out, or a $1,000 bond, or whatever it is. And people are in jail because they don't have the means to get out of jail, but they're being charged with a minor offense. And usually the result of the case, after it takes 30 to 60 days for their case to get processed, they'll end up getting time served. And so a lot of people charged with minor offenses who can't make bail plead guilty just because they know they'll get out quicker than if they pled not guilty and waited and asked for a trial. The system, it doesn't work. And so therefore, when COVID hit, one of the things that happened around the state and around the country really is that more and more people charged with minor offenses were released pending trial without bail. Now, a lot of those people were homeless and they stayed homeless, but they couldn't go anywhere because they had to stay around to wait for their trial. So, the systems, the problems in the systems are interconnected. And you see that you scratch an arm here and a toe wiggles over here. So that's just the way it is. And if you think our problem was bad, think about Los Angeles with a homeless population of over 60,000. Sure enough, the Supreme Court got another opportunity to address the issue, which they knew when they resigned, when they didn't take the Martin case, they knew this issue ain't going away. This is going to come back. And the case is City of Grants Pass versus Johnson. The decision was announced on June 29, 2024. And when the case came down, the headlines read, Supreme Court gives cities a free hand to deal with homelessness, close quote. So here's the story of that case. In October 2018, basically as soon as they found out what the Ninth Circuit was going to do in the Martin case, the Oregon Law Center, a legal aid organization, NGO, filed a class action in district court in Oregon on behalf of homeless individuals. They named some who agreed to they were the lead names in the class action. The lawsuit sought being certified as a class action, meaning that the action represents all people in similar situations. And they asked for a preliminary and permanent injunction to prevent the City of Grants Pass from enforcing its anti-camping, anti-sleeping, and overnight parking ordinances. Violations in Grants Pass were deemed infractions, not misdemeanors, which means there was no jail time, just a fine or being barred from the city's parks. And that was the penalties for if you violate the laws, including you could be punished by a fine or being barred from the city's parks for a period of time. The plaintiffs alleged that the city's ordinances violated due process in the Eighth Amendment because the city had no shelters. There weren't any shelters in Grants Pass. It's even smaller than Santa Cruz, a lot smaller. Anyone ever driven through it? It's a poke and plum town. By the time you poke out your head out the window, you're plumb out of town. A friend of mine who I went to high school with came up with that line. I loved it, poke and plum town. Their evidence included their evidence in the filings. They alleged, and correctly, that members of the city council, when they passed the ordinance, hoped that enacting these ordinances would persuade homeless people to go somewhere else. The district court entered orders certifying the case as a class action and immediately granted a preliminary injunction pending trial. The city immediately appealed. The Ninth Circuit affirmed without even a judge. They just cited the Boise case and denied the appeal. And they were asked to rule quickly because the city wanted to appeal to the Supreme Court as on an emergency basis, which you can do when there's a preliminary injunction. That's how some of the cases I talked about in relation to both redistricting and in terms of presidential immunity. And the Colorado case got to the Supreme Court. And the Supreme Court agreed to take the case, setting it for argument in this most recent term. The case was notable for a number of what they call amici briefs. The Supreme Court has this thing called amicus curiae, friend of the court. If you or your organization is really impacted by a case that the Supreme Court has taken for argument, there's a procedure that you can ask the Supreme Court for permission to file a brief in the case because it really impacts you and you'd like to be heard, and tell the court how it impacts you and what your feelings are, what your belief is. And this is common. Most Supreme Courts have a lot of them. And in some organizations such as the ACLU and the National Institute of Mental Health and IMH supported the plaintiffs. But the overwhelming number of briefs argued that the Boise case was decided wrong. They were filed by almost every major city in the Ninth Circuit in all 7 states. 25 additional states, the 9 states of the Ninth Circuit, plus 16 others filed amicus briefs because they were afraid their circuits would decide the case the same way. And any numbers of law enforcement agencies, chambers of commerce, etc., filed briefs saying this case was wrong. No surprise, by 6-3, the court held that the Boise decision was vacated as incorrectly decided. Justice Gorsuch wrote the majority opinion. The Supreme Court divided 6-3 along the lines we've talked about before. Sotomayor, Kagan, and Jackson were the minority. Justice Gorsuch's majority opinion reviewed the factual context. And when he described the facts, he really did a good job. I didn't have any argument with it, and I thought his description was somewhat fair. He acknowledged that homelessness was a massive problem for local communities, especially California, which had half the nation's homeless population. Homeless encampments were more and more common, and they presented real problems for communities where they were located, including sanitation, public health issues, fires, drug use, and the like. And local authorities had a hard time dealing with them for social, financial, and political considerations. All true so far. No argument. Furthermore, the briefs filed by impacted cities noted that the Boise case exacerbated their problems. Homeless people were increasingly resistant to any attempt by local authorities to limit where people decided to place their tents or regulate the conditions and operations of homeless encampments, such as not allowing butane tanks because of the fire risk, requiring some kind of organization and sanitation, having porta potties, etc. Trash pickup and the like. Cities and towns also claimed, possibly with some truth, that anti-camping and sleeping laws were not intended to stigmatize the homeless, but merely were tools needed to give local authorities the means to somehow regulate these encampments for the benefit of all. So that was how he summarized the case, and I think he hasn't said anything I strongly disagree with. Homeless's opinion, including Grants Pass ordinances, made 5 points. His opinion upholding them made 5 points. And this is in some places where we might have a little disagreement. First, based on history and most precedents, the 8th Amendment goes to the amount of bail or fines in relation to the crime and the severity of punishment after conviction, both in terms of its severity, exact severity, like is it cruel, or is it grossly disproportionate to the offense. It was not intended to limit what conduct may or may not be classified as criminal. That wasn't what the 8th Amendment was designed to protect. And there's some truth to that. Further, neither modest civil fines nor bans on entry to public property are themselves either cruel or unusual punishment for infractions. Second, that's first point. Second point, conduct may be prohibited, proscribed, even if some people, because of a condition, may not be able to refrain from committing it. And he cited being drunk in public. He cited the Powell case. Third, Grants Pass ordinances prescribe conduct by everyone, regardless of their housing situation, not only when such conduct is committed by homeless people. The ordinances were neutrally applied to all persons. Now, the problem with that is that nobody in their right mind is going to commit that act unless they literally have to. If you want to take your kids outside camping, you're going to use your backyard rather than the public park, or you go to the police and you'll get a permit and they'll give you one. So here I think he's a little off. But he says it's true that neutrally, as written, this ordinance applies to all persons. This is unlike the California law that was issued in the Robinson case, which only singled out a particular status for punishment. If you're a narcotic addict, you get punished. That was the problem with the law in Robinson. Fourth, giving an injunction is improper. District courts should not uniformly enjoin enforcement of criminal statutes because some defendants, some people might not be able to avoid doing the prohibited act. Whether a particular person has a status or condition which renders them incapable from committing a prohibited act is an issue that is properly raised as a defense in a case-by-case basis. So if you're charged, you say, Judge, I had no choice. But you don't do it at the beginning and say, we're just going to enjoin this application of this law everywhere. Now, the problem with that is most people charged with the crime aren't going to take it to trial. It's too minor. They don't have the resources to mount a defense. And especially if it's listed as an infraction, because under an infraction, because you can't go to jail for an infraction, you don't get a free public lawyer. You get a free public lawyer if there's a risk of being involuntarily locked up, whether civilly or criminally. You don't get a free public lawyer if the only thing at issue is you might have to pay a fine. That's why you don't have to see public defenders defending people charged with speeding tickets unless they've got so many repeats that the statute provides they can go to jail. And the fifth point he makes is that this is a massive, complex problem with local peculiarities and concerns. So such issues should not be decided by unelected judges. You've heard that from me before, and I think there's some truth to that. Such issues shouldn't be decided by unelected judgments. Often these judges are far removed from the localities where the problem persists. And maybe homelessness is best left to state and local entities who are answerable to the communities that they represent. The idea of democracy. So that was his opinion. Needless to say, California, people in California, the cities and the state government was happy. Our governor, Gavin Newsom, signed the amicus brief in support of the argument that Martin was wrongly decided. The dissent. Justice Sotomayor wrote it, Kagan and Jackson joined, and it's very good. It would hold that the Boise case was properly decided and should be followed. The grants law, the laws and grants passed do not differentiate between voluntary and involuntarily homelessness, but we know that it's homeless people only who are going to be charged, who are going to be subject to this. And grants pass has no shelters. So one cannot be punished even just by a fine for breaking a law, sleeping in public, because doing so is a biological necessity. Human beings have to sleep. Yet homeless violators end up with a criminal record, even for an infraction. They might lose their property from the time that they're taken into custody until they're released. Their stuff is gone. If they might lose their property, they end up with a record. They might even lose public health benefits. People who are convicted, if it's a misdemeanor, you can lose your public health benefits. Grants pass ordinances tell homeless people to stay awake or risk arrest or go, or stay awake or stay away. That's basically what their ordinances say. Quote, the Constitution provides a baseline of rights for all, rich and poor, housed or unhoused. This court must safeguard those rights, even when doing so is uncomfortable or unpopular, close quote. Justice Brennan once said that rights may not be subject to a vote. They depend on the outcome of no election. There's something to say for that. The dissent acknowledges the depth and complexity of the problem, but the only question to the dissent is whether the Constitution permits criminalizing sleeping outside when there's nowhere else to go. In the end, such statutes are unnecessary. Communities have other tools, and criminalizing homeless people who sleep outside is at best a whack-a-mole rather than an effective means of protecting the community. Now,
Sorry.
Yeah. okay.
Sorry.
The one thing that Justice Gorsuch's opinion doesn't deal with is the idea of due process under the 14th Amendment. It may not be covered under the 8th Amendment, but does it violate fundamental due process to punish a person for an act he has no choice to commit because he's a human being? And unfortunately, sometimes you get the wrong decision because the people who plan the case rely on the wrong law. The Grants Pass, people who objected in the Grants Pass case relied on the 8th Amendment because they were relying on the Boise case. That was why they won. But the Boise case probably itself had a problem. If you focus just on due process, maybe you get a different answer. Because as the dissent pointed out, there's a case out of Arizona which held that the government cannot die of necessary medical care because the person had not resided in the county for a period of time. Unlike your Hamburg case, Gunther, that's not the law here. And another case held that banning people from public places, if not a resident, may violate due process. So there's some authority that you could have made an analogous argument under the due process clause. So where do we stand? Well, we stand with the fact that right now the cities can outlaw camping and sleeping in public. I think the Supreme Court wanted to put an end to federal lawsuits filed by service organizations on behalf of homeless people. Because if they had, for any reason, affirmed this, anytime a city tried to enforce a rule against homeless people, you risked a federal lawsuit being filed. And local communities, from the very large to the very modest, have to respond to subsuits. And it costs major bucks and strains local resources to do it. Our county councils, the county council in a small town like Grants Pass, has neither the facilities nor the experience to litigate in federal court. Federal litigation is a separate issue. It's a different ball of wax. It's not like walking into a small claims court or walking into a muni court. It's a big Megillah. It costs a lot of money. It takes a lot of time. The federal rules of civil procedure and the federal rules of evidence put you through a lot of hoops that everything has to be pre-tried so that the most number you define the number of issues in contention before the case ever sees a judge. There's rules that make you do that. And it's limited local resources. Lawyering costs money. And not to mention NIMBY is alive and well. But I think a strong argument can be made that due process, not the prohibition against cruel and unusual punishment, does have limits on what the state may prescribe as criminal conduct. If a statute violates due process because it does not satisfactorily define what conduct is illegal, should it follow that a statute also violates due process if it punishes a person for conduct which the person, due to his condition, cannot avoid committing? That's due process. Me, I think the dissent's correct that it's wrong to criminalize homeless people for being homeless. But I think the Supreme Court on the 8th Amendment probably is right. The 8th Amendment is not designed to tell states what they can make a criminal conduct. It talks about punishment, bails and fines. It doesn't talk about what is or is not a crime. That's a different issue. And putting it on the Eighth Amendment, I think, was farther than the Supreme Court was ready to go. And I think to some extent, ready than they were prepared to go. But to what extent are communities, but if it's, communities should have the ability, the right to manage public property for the enjoyment of all, including people who have no other place to go. But to what extent are the community's taxpayers obligated to provide, regulate, and support camping space for homeless people who choose to go there? It's a moral and a legal issue. It's both. Yes, we are our brother's keepers, but to how much and to what extent? Would a state law that requires every community to set aside a parcel of public property for homeless encampments with sanitary facilities and other services, would it pass a vote? And if the people and the taxpayers in that community didn't vote to say yes, could a panel of unelected judges tell them they had to do it? Is that the way we should run? That's why I say homeless people themselves and the problem of homelessness ain't going away. That's it. Because it's not going away, and there is no, I don't think there's an easy answer. Okay, any more comments? Yes.
Well, so bottom line, do you think this is a settled issue, or was it controversial enough that it will be retried in some way?
I think that most organizations right now will realize that they don't have a receptive audience in the Supreme Court. And that they will try and find other ways to solve the problem. To try and solve the problem, either by getting judges to agree not to fine people. And if people are being fined and can't pay the fine because they have no money and then are being sent to jail, maybe that's the place to fight it, is in incarceration for failure to pay a fine when you have no money. Does that violate due process? I think there are other places to fight this. I think if the Supreme Court changes and we get back to a more liberal court, then I think you might see another case come up and fight it on due process grounds. I think as far as the Eighth Amendment concerned, it's a settled issue. I don't think that laws prohibiting camping and sleeping in public parks by homeless people, is going to survive an eighth attempt. The Eighth Amendment doesn't prevent you from doing that. Due process may prevent you from doing that, but I don't think this court is going to go that far to say so. And I don't think organizations are going to bring law and bring challenges. That's my take on it. I could be wrong. Anything else?
Thank you.
It's lunchtime. Next time, free speech and social media is like we don't have anything else to worry about.